On Monday morning, August 18th, a 44-year-old man in Lindsay, Ontario, woke to find a 41-year-old intruder inside of his apartment. According to court documents, an altercation ensued, and the homeowner allegedly used a knife, leaving the intruder with life-threatening injuries that required an airlift to a Toronto hospital. The intruder, who was already wanted by police on unrelated charges, was arrested and faces counts including break and enter, possession of a weapon for a dangerous purpose, theft, mischief under $5,000, and failing to comply with probation. But in a twist that's ignited public outrage, the homeowner himself was charged with aggravated assault and assault with a weapon. The case quickly drew sharp reactions from politicians. Ontario Premier Doug Ford called it evidence of, quote, a broken justice system, emphasizing that people should use all resources possible to protect their families. Even Kawartha Lakes Police Chief Kirk Robertson felt compelled to respond, issuing a statement amid the backlash. He acknowledged the emotional responses, but stressed that commentary has been, quote, unjust and inaccurate. Under Canadian law, he noted, individuals have the right to defend themselves and their property, but those rights are not unlimited. Defensive actions must be proportionate to the threat. This incident has thrust Canada's self-defense laws into the spotlight, laws that were reformed in 2012 to simplify claims, but have since led to more complex cases. Legal experts emphasize there's no absolute right to self-defense. It all hinges on reasonableness. Kent Roach, a professor of criminal law at the University of Toronto, explained that while homeowners can argue self-defense or defense of property, success is not guaranteed. It's ultimately up to a judge and a jury to determine what is reasonable in the circumstances. He added, quote, that the accused gets the benefit of reasonable doubt, but just because the force feels reasonable to you doesn't mean that it will for others. Roach points to a landmark Supreme Court case, R v. Keel, a cautionary tale. In 2016, a Hamilton resident, Peter Keel, shot and killed a man trying to steal from his truck on his property. Initially acquitted, the verdict was overturned on appeal, and after a retrial in 2022, he was convicted of manslaughter and sentenced to 8 years. Factors like not calling 911 or turning the lights on played into the court's view that his actions weren't fully reasonable. Criminal defense lawyer Joseph Newberger added nuance, saying Canadians absolutely have the right to protect themselves and their property or their loved ones from threats. If an intruder wields a knife or gun posing imminent harm or death, significant and even lethal force may be justified. But it gets trickier with other weapons. Self-defense laws account for trauma and split-second decisions, but if you disarm the threat and continue the assault, say with a baseball bat, that crosses into excessive force, potentially leading to charges like aggravated assault. Another expert, Toronto-based criminal lawyer Tanya Kent, warned against misinformation swirling online, saying, quote, I've seen comments claiming there's no self-defense in Canada, but we fully have a section in the criminal code for it. She added, however, force must be proportionate and not excessive. In this Lindsay case, the severity of the intruder's injuries requiring airlift suggests why police proceeded with charges, though nothing has been proven in court yet. As this matter heads to the justice system, police are urging the public to follow it closely rather than jumping to conclusions. The investigation was impartial, they say, and only limited details are out to protect the process. Ultimately, this story reminds us that while defending your home is a fundamental right, the line between protection and excess can be razor thin, and it's the courts that get to draw that line. Back to you.